Like everyone's in.
They are all in, right?
Hi, everyone, and I think we'll give folks just a minute or two to get connected to audio. But while everyone's connecting, I'm Leslie Parker. I'm an attorney at Adler Pollock and the chair of the Young Lawyers Committee for the FBA. And we're really happy to have everyone here and thankful that you could join us in Zoom. We'd love to be in person, but maybe next year. So we are honored today to have Magistrate Judge Patricia Sullivan join us for really a discussion on tips and tricks for young lawyers and those, practicing for her in front of her for the first, 5 to 10 years of their career is what we'll really be focused on. And just a little bit of background on Magistrate Judge Sullivan. She was appointed to the bench in 2012, and she also serves since 2014 as the presiding judicial officer of the Hope Court. She's a graduate of Wellesley College and Georgetown University Law Center, and she had a long and impressive career at Edwards Wildman before taking the bench in 2012. And for those of you who haven't had the opportunity yet to practice in front of her, you'll find that it's a joy, and she really is a great resource for younger attorneys. So with that, Magistrate Judge Sullivan.
Thank you, Leslie, and hello to everybody. I hope it is a pleasure. I just finished an argument, and I think someone who is at that argument is a participant. So he might be raising his hand to say, "No, that was not a pleasure. That was brutal."
Always a pleasure, Judge.
Thank you. I love talking to young attorneys, and I think the thrust of what we're here to do today is to have me tell you that there are no tricks, but lots of tips that I can give you, probably focused on me, but I suspect that most of what I will say is going to be true for just about any judge you're going to find yourself in front of. Leslie, I don't know if you wanted to steer me in a certain direction. I'm happy to go.
That sounds great. And a few housekeeping measures before we get started. In order to get CLE credit, please email your name and bar number to Mason Waring. He'll put his email in the chat box. So just to make sure that you get that CLE credit. And then additionally, if you have any questions along the way, we're the perfect size group. Just feel free, either raise your hand or speak up, and we'd be happy to take questions. You can also put them in the chat box if you'd prefer, and I can look at them from there. So Judge, I thought it makes sense to start in terms of things that younger attorneys are doing more often than not. And, that's a lot of brief writing. And sometimes, they'll start to have their first oral arguments in federal court. What have been some of the most impressive arguments that you've seen, some of the qualities of those, whether it's, during oral argument or in brief writing?
I think and they're two very different things. So in my experience, a beautifully briefed case yields a very helpful oral argument that goes beyond the briefs and really begins to inquire into the kinds of things that, as I'm finally deciding the issue, I want to sort of deal with. So I'm always thinking, working backwards from an opinion, that's my work product. I need to push out an opinion. And when I write an opinion, I want my reasoning to be clear and well organized and well supported. And if I have a proposition that has no support, I'll say so. If it is supported, I'll say how it's supported. And as I'm writing, if there's been a flaw in the work from the attorneys, I find a hole. And often my law clerk and I will say to each other, why didn't we ask that question during the argument? Oh dear. Rarely I'll actually like send out a little inquiry and say, please tell me this. So from the perspective of the practitioner, picture that judge with that problem. And so here's just some thoughts on the written product and then the oral argument. From writing, first of all, less is more, and hyperbole is usually unnecessary. I am almost never persuaded by mere hyperbole. And it gets in the way, and it takes up a lot of time, and it often causes me to say somewhat skeptically, oh, this must be a weak argument, or they wouldn't have felt they needed to bother with hyperbole. One of the things that is underneath every time you submit a piece of writing to the court, or you make an oral argument to the court, that I have to talk about a little bit is your personal reputation. So we're a very small bar. Everybody knows everybody. And it's a huge factor in that your reputation is built over time, over multiple appearances. If you're appearing before a judge you never appeared before, you build your reputation in that case. And one of the things that absolutely happens is that I begin reading a brief with a preformed opinion about the writer's reputation before me. Is this a lawyer whose case sites always don't support the proposition, so I got to read every case and be skeptical? Or is this a lawyer who, if there's a site with a pin site, it's going to stand for the proposition? So eventually I'll read through and I'll read the case, but I don't need to make those inquiries because I'm dealing with someone with a good reputation. And I literally think that. So think about your reputation, and it's just never worth submitting something sloppy that undermines your reputation, because it will come back to bite you. So if you are a lawyer who has established a ground record of, don't rely on the cases I cite because they never stand for what I say they stand for, that becomes known to judges. So be scrupulously careful about that. I said it a moment ago, don't waste time on hyperbole. Every once in a while that's useful. And I'll just give you an anecdote that I actually observed when I was a very young lawyer, and I have used it year over year. And the lawyer that did this was more experienced than me at the time and is still practicing, so I won't say who it is, but that lawyer had followed this rule of reputation very, very scrupulously and was very careful about never being hyperbolic and exaggerating, and this is outrageous, this is misconduct, bad faith, all that garbage was omitted. And in a particular case, that lawyer wrote a brief that was still very like stick to the argument, walking through it, but then appearing in court said, Judge, you know me. I have never gone hyperbolic on you, but I am now going to go hyperbolic in this situation for this circumstance and what happened here. And because of the lawyer's reputation and because of the clean, non-hyperbolic briefing, everybody in the room sat up and listened. That was a powerful moment. And what it really said to me is, as a lawyer, you build your reputation, you're incredibly careful about avoiding hyperbolic stuff, particularly in the writing. You let the cases and the facts and the evidence that you're marshaling speak for itself. And then in oral argument, if the situation calls for it, you then step back and say, this isn't what I usually do, but this situation calls for it. The other thing I see in in briefs that's really problematic is when each side briefs kind of out there and the correct decision is in here and no one has briefed the arena where the correct decision has to go. And my goal is to get the correct decision. And when that happens, I end up ignoring both sides' briefs and doing my own analysis because there's no one telling me what the land in the middle represents. If one party goes out there, the other party can choose to go to the middle, concede the weaknesses, explain why they nevertheless go towards the result they're looking for. It's critical, I think, and it becomes really the difference between being the lawyer whose work is persuading the judge to go to the middle and concede the weaknesses. The last thing I would say on briefs in your beautifully well organized short type brief that walks through the analytical outline of how to get to the decision is essentially sentences fall into three categories. There's sentences that are absolutely supported either by a absolutely controlling rule of law or a lock dead piece of evidence. There are sentences that arguably are well supported. And in each of those instances, put the support. And then there's sentences where you're out there and you have no support. If you don't put a supporting citation at the end of an important sentence, I assume that's what it is. It's an out there. It's unsupported. And I'm not going to adopt it as where I go unless my own research suggests that it was an error on your part in not supporting it. I'm going to assume it's no support. And in my opinion, I might write, plaintiff argued X, but provided no support. Defendant said X is not true and supplied ample support. Cite. That's the ballgame. So if there's an important sentence and you don't have a citation at the end of it, stop and say, is this really argument or do I have support? So then put it in. Or if you have no support, I mean, maybe you're then concede. We're going into new territory now. I'm asking you to adopt my sentence because it's the right next step to extend the law. And that's why there's no support. But if there is support, then include it. And if it's a sentence that needs to be supported, but there is none, then take the sentence out because it's going to undermine the credibility of your arguments. That's sort of my kind of big picture suggestions on brief writing. Oral argument, critical is that everybody is thoroughly prepared. This morning's argument was probably twice as long as it was scheduled to be. It was some very interesting issues, beautifully prepared attorneys. And I was prepared. 90% of the time, I'm very prepared. So I'm going to be asking, what about this case and this footnote in this case? We literally had that question come up in this morning's argument, and all counsel knew about the footnote. No problem. Everybody was all over it. So that's the level of preparation. I think the way to prepare is immersion in the facts and the law, and really thinking your brief as a foundation and thinking forward from your brief to a ruling and what's going to come up in how you think about the worst arguments are the ones where somebody takes the brief, puts it on index cards and reads them. I've already read the brief. That's a total waste of time. The other worst mistaken argument is to ignore the judge's question and segue right back to your outline, because the questions that the judge is asking, if I don't get an answer, I assume it's because there is no answer, and I will decide based on there's no good answer to this question, and therefore that party loses. So listen, and if you don't know the answer, no problem. Tell me. I think it's in the record. Let us send you something after the hearing's over. Or this morning we actually had two counsel. One said, I think it's in the record, and I think my colleague will send me an email in 5 minutes. And he did. So that's, but then in the same argument, the other party said, hey, I just heard an argument that I didn't have a chance to brief. And I said, great, you can have a chance to brief it. Let's make a little mini post-hearing schedule. So don't be terrified that if I ask a question and you have the, oh my God, there is an answer to that question and I don't know what it is. Just say, there's an answer to that question and I don't have it in my head right now, but let's make a plan for getting the answer before the court, before an opinion is rendered. I want the answers and I want to help counsel to get the answers. So don't worry if you find you can't answer a question. Not a problem. And I think the last thing on arguing remotely for the first time is it's kind of the same as I will mention when arguing remotely, make sure that you are appropriately dressed. Amazing how often that doesn't happen. Early on in the pandemic, I did have an argument where one of the attorneys was making a long argument and the other attorney thought it was a good opportunity to stand up and grab something. No pants.
Without pants. Did that really happen? Wow. So just think about all that kind of crazy stuff. Think about making sure that there's nothing that's going to happen in the environment in which you're delivering your argument that's going to throw you off and get you distracted. Close the door for the dog. Move the device away from the window if somebody's going to be paving the driveway. So no cat filters.
Yeah. Well, no cat filters. That was the best. Okay, that's my answer.
So, kind of segueing from that, a lot of the times you're going to have young lawyers in front of you on these arguments are going to be discovery disputes, right? That's kind of where it starts. And I know that you do discovery conferences before, briefing and before everyone comes in front of you. Formally, what are your expectations for counsel before the discovery conference? So what do you expect should have happened in that meet and confer? Because I think I know what should happen, but I do think in practice it varies widely. And so I think it's helpful to know what younger attorneys should be doing in advance of getting to you.
Yeah, well, I think what's really key is distinguishing a hardcore needs a decision, might be an appeal issue, discovery dispute, from if you talked it through carefully, you'd solve it, discovery dispute. When I get on the phone with the parties, I've got those two worlds in mind, and I have more than once ended a discovery dispute very quickly and issued a little text order saying, based on the discovery dispute, this needs a motion and a decision, and terminated as a discovery dispute. Judge Smith is very strict about, in his cases, I think Judge McElroy and Judge McConnell are a little more loosey-goosey about whether something must go to discovery dispute before it can be filed as a motion. But I think Judge Smith has denied motions without prejudice because they didn't ask for a conference. So how do you prepare? You prepare by having a robust discussion with the other side about, if you're looking for documents and information, what are you looking for and why? What do they have? What format is it maintained in? What are the practical problems that they've got, which is causing them to say, no, you can't have any of it? And how can you solve them? Because that's what I'm going to ask. So if we're in a discovery dispute, that's a real discovery dispute, I'm going to say to the party looking for something, and it may be obvious from what they've provided. So I ask people for short letters. I want to just see the dispute like crystallized, not briefs, just letters. Give me the letters. And then we get on the phone and I'll begin with the party looking for something and hear what they're looking for. And I might say, for example, boy, you're looking for any and all, but you just told me all you need to know is A. Did you ask the defendant how A is maintained? How do they answer that question? And they're like, oh. So then I might turn to the defendant and say, where's A? How do you keep it? And the defendant might say, well, actually, we don't maintain A as information, but we do have A plus. And that's on the corner of my desk. And I say, great. All right, you can produce it tomorrow. Actually, probably tomorrow. I say, okay, party plaintiff, what else do you want? Other than A plus, what do you need? And that's the process that I'll go through. It's a little surprising to me that it gets to needing me to do that. I mean, very often with those kinds of disputes, my takeaway is a good meet and confer would have solved this problem. But I think when the defendant is asked by the plaintiff's counsel, how do you maintain A? The defense counsel may be thinking of every way to avoid saying, well, actually, we have A plus and I already got it from the client and it's already on the corner of my desk. But when I ask, I get the answer. So maybe there does need to be a discovery dispute, but that's it's really thinking very, very practically. I do not have discussions of, what are the rules say and cite some cases. It's really a practical, what's relevant, why, what do you need, what's the problem with giving them what they need, how do we solve the problem?
So do you think that attorneys need to make the entirety of their arguments during the discovery conference? Because I know it varies from judge to judge, right? Some judges will have, an informal discussion and may change their mind about what they initially thought if it moves to motion practice. But others, really make a decision right there in the discovery conference, even though it might be more informal. Do you think?
Yeah.
Do you think all of the argument?
We struggle whether you make. So a couple of things to answer your basic question. I would say, without belaboring the point, during the informal discussion, you should make sure the judge listening understands the full array of issues. And, for me, if there are big picture issues of law, then that ought to be, if it could be an appeal issue, it needs to be on the record. That's the way I look at it. And I don't want to deal with, in the oral argument, once I decide the big picture legal issue, we'll get to proportionality and get, kind of micro down on what's out there. But, and one of the things that I think we all struggle with, and I'll confess that I do sometimes get a little bit coercive in this so-called discovery happy talk session. I might, for example, say, if this moves to motion and the motion's referred to me, here's how I'll rule. You'll lose. So would it be a good idea to keep talking now? So that's part of why you want the judge to know the full range of things that are in issue for this dispute, because I see my job as solving the dispute. And that means done. And maybe it means this part goes to motion practice, this part has been resolved, these two requests are agreed upon and off the table. These two requests aren't really agreed upon, but little pressure and it's going to go away. I have occasionally, I think, issued text orders coming out of discovery disputes that sound a lot like orders. So it gets a little funky, but my rule of thumb is, if a lawyer says, this is an appeal issue, I need this on the record, then I'm all in.
Yeah.
I don't want somebody impaired by the fact that it was an informal discovery dispute. Now they don't have a good record.
That's very helpful. And on these, discovery disputes, has the last year, with COVID or otherwise, what you've been seeing, the types of disputes changed over time, or the volume, or have you seen any pattern, or is it generally stay steady and the same?
Well, I think the pattern is really that during intense COVID, at a stage when no one knew what was going to happen, I think a lot of cases moved to slow-mo. And there weren't a lot of discovery disputes because people were like, we don't know what's going to happen. We don't know when it's going to happen. And then everybody kind of settled down and said, okay, we're going to keep working our cases. We're just going to do it remotely. We're going to take depositions remotely. We're going to possibly try our cases remotely. And now we're coming out. Now you can try your case in person. So I think what I would say I've seen in the last 6 months is that discovery disputes have gone way up, just in terms of the number of things that now need to be resolved. And my takeaway is that there's nothing different about it. It's simply that why fight about discovery when you're not even going to be able to take depositions, because you don't even know how you can do that safely. And then people said, okay, we need to move our cases. And now they're moving, and lo and behold, lots of discovery disputes.
That makes sense. Things are catching up, I guess.
Yeah, I mean, I think there's a lot of, right now, volume that's moving through the pipeline that had slowed down. So there's a lot of activity in cases that would have happened a year ago and didn't because of the pandemic. And now it's all flowing.
Right.
And one thing, Leslie, that I just need to say for my practice, most of the time I do discovery disputes just on the phone. I did them that way pre-pandemic, and I do them that way through the pandemic, and I still do them that way. So it's not, and I don't make a record. Every once in a while, for example, there's a pro se litigant, then I'll put it on the record and make a recording of the phone call. If it's a phone call, sometimes with a pro se, it's just a discovery dispute, but we'll actually have a Zoom session where I want to see and assess what I'm dealing with. But for a garden variety discovery dispute that just needs some talking through, including discovery disputes that arise in the middle of depositions, where parties are in a deposition, got a problem, call me. I do those on the phone with both counsel and not on the record.
And I'm sure everyone's happy for the Zoom break.
Yeah.
Yeah. So kind of on that note, just talking about getting to know the court and, you know, how to get to know the court now that things are starting to open up. So one question that I had was, you know, you often hear know your judge, right? When you're drafting a brief or before oral argument. Do you have any suggestions how for new lawyers, how do you go about knowing your judge? I can think of a couple things, but
well, I think one thing is to just to do a sort of quickie Westlaw, JU paren Sullivan search, particularly in your topic area, and just sort of a casual survey of decisions. If you're writing a brief and I've written something absolutely on topic and you cite something from Iowa, and you don't cite my case, not only are my feelings profoundly hurt, not really, but I say to myself, this person doesn't know the judge, and cite my case back to me, which tells me that A, you know me, and B, you understand that your case and my prior case are similar, and you're going to go on and explain to me why I should decide this one differently from what I did in the past. If you think I screwed it up in the past, but just be aware, I'm going to remember my old case. And when I kind of take it under advisement, I might go back and say, well, I know I did good research to write that old opinion, so I've got confidence in that. I don't have confidence in this lawyer's brief who's citing cases from Iowa. So I'm going to go read my own opinion as the starting point for the analysis. So that's really an easy peasy way to know the judge. Don't pander to the judge. Don't say, oh, as brilliant Judge Sullivan said in her absolutely impeccable decision that I'm now going to say is wrong. But, throw it in there. It's very helpful to me because I know the research I did to come to that decision. So no, that's a very easy aspect of know your judge. The other thing that's easy to do, pandemic or in person, our hearings are all public and you can watch. So you can sign on as a member of the public to a hearing, for a remote hearing. And of course, someday you can wander in the courtroom and just watch for no reason. We sort of love it when that happens.
So on that note, do you have any updates on when you think you'll be back in the courthouse? Or is that the $1 million question?
Well, so here's the deal. The courthouse is officially opening on June 1st. I know that Nora's eavesdropping, so if I say anything wrong, she's going to immediately unmute herself and say wrong. And in the courthouse, we've done unbelievable work, and I have to say, Judge Smith and Frank Perry, OMG, they have done such good work. So we've got spaces, jury assembly room, courtroom 1, that have been vetted for safety, adjacent conference rooms for sidebar conferences, jury deliberation rooms. So those spaces have been studied and are ready, willing, and waiting, and have been. Actually, the grand jury has been meeting in the jury assembly room almost seamlessly since last, I think it was late June that they started, and then they stopped in the surge in November, December, early January, and then they restarted. So we've had the public coming in, listening to the grand jury, and it's lawyers, witnesses, grand jurors. Grand jurors are a lot. It's a 16 to 24, I think. And not a single episode of, oops, there's our COVID transmission. It's worked beautifully. So our safety mechanisms, we have extraordinary confidence in them, and the next phase with reopening. So in terms of the court and these spaces, open. Yay. However, there's always a footnote. My courtroom is in the Pastore building. It has not been tested. It has not been vetted. It has not been examined. It's an inside space. So it's totally dependent on air circulation for safety. And for the we're the court staff, I think we may be at 100% vaccinated so we're all pretty good. Which of course still doesn't mean that's not 100% safe, but it's pretty safe. But then the public is coming into a courtroom and they have to be allowed to come, and we don't know their status. So the room has to be safe. And we haven't even tested those rooms, never mind figured out. So when it comes to hearings in the Pastore, not going to happen until unknown future, probably fall. So if someone appearing before one of the magistrate judges wants an in-person hearing, you need to affirmatively ask for it. We need to run over to the courthouse staff in the courthouse and beg for a time slot in the space that's safe. And the priority is going to be for jury trials, criminal sentencing, pleas, criminal matters that are overwhelmingly must be in person. So where oral argument might be nice to be in person in a civil case, I actually think it's just as effective remotely. No, that's not going to have the kind of priority. If the room's available, no problem, but you'll get kicked out if something important comes up. So until we get to the point where the Pastore courtrooms have been vetted, the magistrate judges are essentially, as directed by Judge McConnell, we're going to continue with our hearings being remote unless and until. You think you want in person, absolutely ask, and we'll see if we can figure it out. But warning, probably it'll be no. Nora, have I got it kind of straight?
Perfect, Judge. Perfect.
So, on that note, how do you work with your court staff, and how do you expect lawyers to work with your staff?
That's a great question. I work with my staff very much on a sort of a team model. I have two law clerks, Carrie Mosca and Pat Cunningham. Those of you who are, you're all young lawyers, so forget it. I was going to say, Pat actually was Judge Lisi's law clerk for many years, so he's back to the court after a little hiatus away. One of them is assigned to work with me on every case, every civil case. In an ideal world, the assigned law clerk will have read your briefs. She and I will have, I'll have read the briefs too. We'll talk. I'll have a bench memo, which is calibrated to our discussions. That is, I'm not going to have my law clerks work hard on an issue that's not a big deal, but I'll get the law clerk's perspective. The bench memo will suggest to me areas of questions for oral argument. That's really big. I see that as a key function for those law clerks. And then the law clerks will help with the drafting of an opinion post. In my mediations, both of my law clerks, more Carrie Mosca, but also Pat, if Carrie's not available, Carrie's the primary mediation law clerk, will be in direct communication with the parties. I know some judges are very prickly about law clerks being contacted by lawyers. I'm not, but I also urge people to be mindful that if it relates to a mediation, email Carrie. If Carrie gives you a bounce back because she's on vacation, then follow up with Pat Cunningham. And I myself really avoid emailing parties. So you'll get emails from my law clerks, and you probably, if you're clever, you'll say, I think she wrote that. I don't think the law clerk wrote that. You would probably be right. But I, as a practice, just because in private practice, I remember those awful moments where you sort of populate the email and you make a little sort of finger slip, and all of a sudden you've, instead of addressing it to the person you want to get it, you've addressed it to opposing counsel by mistake, but then you already hit send, and it was your entire strategy for your case that you just sent to opposing counsel. So I remember those things happening. So I just have an absolute, so that my email box doesn't start populating me to be emailing lawyers directly. So don't email me directly. There are lawyers out there who have my email because I work on court-related things, and sometimes they do. And when they do, I invariably, Carrie always sends me an email and saying, he's not supposed to use your email address. I said, oh, he's too old to learn new habits. So I think being very comfortable in emailing with those two is fine. If it relates to what's going on in the courtroom, a hearing, you've got a conflict with the timing of the hearing. Martha Saucier is my courtroom deputy, and she is absolutely in charge of scheduling. If you've got an emergency motion, she's the right person. If the motion is at the time of your child's high school graduation, email Martha Saucier. We want you to be really comfortable bringing those problems up. If you've got a document that you want to incorporate into your argument and you have a question in your mind about how to do it, email Martha. So all things courtroom, Martha, all things mediation, elbow clerks. And here's the key: always CC the other side, unless it's mediation and we're truly now in ex parte communications are okay. So ex parte communications and mediation are okay. We always stop when we get an email from a lawyer. Well, Carrie stops and looks at, was the other side CC? I mean, that's big. And if not, and sometimes with pro se litigants, it's a constant problem of reminding them that they've got to CC the other side. That's really key. But we are in the public service industry. We are delivering a service to the public. All of my team, I want them out there helping the attorneys to the max, consistent with fairness, and people get rid of the small stuff, get that out of the way, and let's get to the merits. At the same time that I want to keep myself a step removed, because I think that can lead to mischief. So my staff are the people to communicate.
Great. Well, so I have a lot more questions. We could go on all day, but let me ask you, some of the just general advice questions we have, and then we can go back if we have time. But so, from your perspective, what do you think the best piece of advice that you received as a young lawyer was?
I know you told me you were going to ask me.
I know.
That.
I don't know what my answer would be, so it's not a fair question. But or the piece of advice that you wish someone had given you, if that's.
I think the piece of advice that I wish someone had given me was be flexible. You don't need to win every battle. your goal is to get to the best place in the war. It's your client's dispute, not yours. And your job is to do the best. And sometimes I see people whipping themselves up over issues that where a calmer, how does this really, when we're up in the Court of Appeals, how is this going to matter? And it doesn't. Sometimes whether certain discovery gets provided, people are fighting like tooth and nail to prevent discovery from flowing to the other side. And this kind of think big picture, I try to say to lawyers who are doing that kind of an argument, wait a minute, if the Court of Appeals says this evidence, if it had flowed, then the court would have looked at it, but the fact that it's not there, the case needs to be remanded because it's missing. So if it's borderline relevant and easy to produce, just produce it. Take that fight out of the case. Don't sweat the small stuff. I think that's the advice that I wish someone had given me, because I sweated all the small stuff, fought every battle, and you really don't need to. And having your eye on the ball and the best outcome for the client can often lead to an elimination of fights. Having a fight because you and opposing counsel are at each other's throats, that's a waste of time. But I think so. My advice is when you've got an opposing counsel like that on the other side, just draw the curtain.
That's great advice, and I know that I personally will use it. I'll draw the curtain. So, and then I guess for the last question, before we take questions from others, is what surprised you the most when you took the bench?
I think actually the thing that surprised me the most was how frequently the middle, what is the gravamen of what's in issue and what needs to be decided was avoided by both sides in the briefing. And the importance of doing what I now do, which is really robustly analyzing the issues, mindful of how I'm going to be deciding them, so that I can get on the bench for oral argument to say, your brief totally overlooked all this. So tell me how you would argue that. So I can get that in argument. So I think that's the thing that surprised me most, the degree to which really good lawyers are not thinking about the circle that's in the middle, which is where I need to be driving myself.
No, that's really helpful as well. So before I, of course, have a number of questions I can continue to ask, but I want to make sure we have about 8 minutes left. If anyone watching on the Zoom wants to chime in with any questions, please feel free. I don't want to take up all of the time. All right, well, I'll keep asking, and if anyone has anything, feel free to put it in the chat, raise your hand, and or just speak up. It's fine too.
So my other advice to young lawyers is don't be shy. Raise your hand. Anyway, so go ahead.
So one of the last getting to know the court question I guess I had was on technology, and I know you and I had discussed this a little bit before then, but if you wanted to share how should lawyers coming in front of you be prepared to use technology, if at all, and what capabilities does your courtroom have now?
Well, of course, so here's the interesting more reality on my courtroom. Once again, Nora pops up because she might have some. Pre-pandemic, The magistrate judge courtrooms were terrible for technology. That's sort of a colloquial term that I think is accurate. You could use an Elmo, but what flashed up on my screen was so old on the bench that it was kind of waste. To the point where if somebody wanted to use a PowerPoint, I would actually load it up on a laptop and bring the laptop onto the bench with me, because what was actually available in the courtroom was really just not usable. I am told that that's all been fixed. And I therefore will be learning along with you guys what's really effective and what isn't, what works and what doesn't. But I believe and expect that it's going to be possible, Nora will tell me if I'm wrong about this, for you to, sort of load stuff you want me to look at and the other side to look at onto your appropriate device, and in you come, and it'll be on a screen, and I'll actually be able to see it, and the screen won't crash every 10 seconds, and it will be quite effective. So I don't really know exactly how all that's going to work, but for the most part, when I would say most of the evidentiary hearings that I've done have involved cases. First of all, I think more on the criminal side. So we've had lots of evidentiary hearings and trials on the criminal side, including in the Zoom format. And whether you're remote or in person, what usually happens in those settings is the exhibits are emailed, pre-marked, emailed to the clerk, to me, and to opposing counsel enough in advance of the hearing, maybe an hour sometimes, but still in advance. I then, tee them up for myself to open them remotely as they come along, and look at them. Zoom has the capability for screen sharing, but I find that I really don't like that during an argument. The only way in which screen share really makes sense, which I've used in evidentiary hearings, is if it's a video. So the video gets shown on the screen share. It's been marked as an exhibit, it's been admitted, and then I'm going to watch it. But that's the one situation where you really have to have it embedded in what you're presenting to me. Otherwise, you can use sort of I guess it's not quite the old-fashioned methods of emailing digital copies. That's still somewhat digital. That said, once we get back into our courtrooms, the capabilities may improve exponentially. So you may say, how do we find out? Well, as soon as you find out you're going to have an in-person hearing in my courtroom, might be September when that happens, I don't know. Contact Martha and say, I want to find out about technology. Our techno staff are just amazing, amazing in their ability to coach people through, teach. And if you're doing a hearing, sort of doing something for the first time and something goes wrong, don't be shocked in a remote environment if Mike Simoncelli pops up in a box, because he's actually been watching to make sure it goes well, to save the day. So we are absolutely want people to be very comfortable in bringing their exhibits of whatever nature before the court in an appropriate way in the course of evidentiary hearings, or in arguments. Sometimes you want to show a document during an argument, and there are an array of ways to do it, from screen sharing to email it to my clerk before the hearing starts. She'll forward it right to me, pre-marked, obviously, and obviously copied to the other side. If you have any hesitation or concerns about the nature of the document that maybe it's a really long document and it doesn't lend itself to screen share. Well, it probably lends itself to email it to Martha. She emails it to me. I print it. And I am sitting on Zoom with paper as you direct me to page 27 and page 48 and so forth. As long as it's fair to the other side and there's no confusion and it's clear, the record is clear, it's clearly marked, we're very flexible.
And I can say that I've done the technology training, or at least fiddled with it in almost all the courtrooms in the courthouse. So it's definitely worth your time to go over there and get comfortable with it, even, in advance of a big hearing or something like that.
Yeah, or even a small hearing, why not?
Right. Right.
And just everybody heads up, when the Pastore courtrooms open, it's a new world for everybody. So come on over in advance.
Yeah, in advance of the hearing, just for fun,
Yeah, just for fun.
Well, I think we've hit 1 o'clock, but Judge, I really wanted to thank you for today. I know everyone here really appreciated you taking the time. It was very helpful, I know for me, and I'm sure for the others on the phone. So thank you very much.
You're welcome.
And we all
Hi to
appreciate
everybody
it.
out there. I see some waves. Oh, good. All right.